In the matter of Harpreet Singh Talwar at the rate Kabir Talwar versus State of Gujarat, Supreme Court dismissed the appeal and directed National Investigation Agency to submit to the special court an additional list of witnesses who, in its assessment, were sensitive or material in as much as their testimony may have a direct bearing on the role of appellant or other co-accused in the ongoing trial and connected investigation. Court clarified that at this stage it would be premature and speculative to extend the allegations against the appellant to domain of terror financing. While prosecution had invoked provisions of the UAPA and had broadly linked the smuggling enterprise to transnational syndicates with suspected affiliations, there was no compelling reason to currently link the appellant and proscribed terrorist organizations either within or outside the country. The evidentiary foundation to sustain such a grave allegation, court said, must be clear and compelling, something that can be seen only after a substantial portion of evidence is led by both the parties. Court said that FIR arises from investigations into a multi-jurisdiction narcotics smuggling operation allegedly executed by Afghan-based syndicates with link to domestic operatives wherein substantial quantities of heroin were illicitly brought into India under the cover of commercial consignments. Court said that the appellant faces serious charges which allegedly carry grave societal ramifications, including the facilitation of cross border drug trafficking, an offense with well documented links to organized crime and public health degradation. The seizure in the connected consignment was part of the prosecution claims to be the largest heroin bust in Indian history, valued at over INR 21,000 crores. The scale and sophistication of the operation involving foreign syndicates, shell firms, medical visas, and false documentation elevates this case beyond routine NDPS violations. The court also said it cannot ignore the fact that multiple key witnesses still remain to be examined, and the trial, while underway, will take time in completion. Out of 24 most vulnerable or material witnesses, 2 have died and 2 others are untraceable. One of the deceased witnesses, a retired customs officer, was found dead on the very day he was scheduled to record his statement under Section 164 of CRPC. The risk of witness tampering or elimination, whether directly attributable to the appellant or not, is a real and present concern that militates against the grant of bail at this stage. The appellant's criminal antecedents, though not involving prior acquisitions under the NDPS Act, include multiple DRI and custom proceedings involving smuggling of cigarettes, undervaluation of imports, and alleged complicity in the corruption offences. These antecedents are relevant only for the limited purpose of evaluating appellant's propensity to interfere with the purpose of justice if enlarged on bail. NIA also highlighted that several accused remain absconding, including the primary foreign conspirators. In that context, appellant's foreign travel, overseas connections, and financial capacity cannot be overlooked in evaluating the possibility of a flight risk. These are not speculative concerns but flow directly from the appellant's prior conduct and profile. Court said that we are conscious of the settled principle of pre-trial incarceration should not translate into punitive detention. The appellant had been in custody since 24th August 2022. While we do not find that this duration alone warrants bail under the present circumstances, the appellant shall remain at liberty to renew his prayer for bail after a period of 6 months or upon substantial advancement in the trial, whichever is earlier. Such a course would allow the prosecution to complete the examination of its core witnesses while preserving the accused's right to seek release at a later and a more appropriate stage.